Davidovich is how you say it, yeah.
That's it. And he is our legal expertise. He's going to talk to us about what we shouldn't do.
So you're a lawyer?
So I'm a lawyer?
Yeah.
It'd be really weird if I wasn't a lawyer to talk to you about legal issues.
All right. Let's do it.
Well, I talk to my clients about legal stuff all the time.
No.
Really?
You should maybe think about rethink that.
Yeah.
All right, what's up? Yeah, so my name is Niv Davidovich. Yes, that is my real name. No, it is not short for anything. No, my parents don't hate me. So, getting that out of the way. So yeah, I am here to talk to you about legal issues that may come up in your daily work. The way I like to do this is I'll bring you up to speed on a couple of things that is relevant in the law, and then we'll just open it up to some questions. Feel free, please don't feel shy. There are no stupid questions. I mean, there are, but I won't tell you they're stupid. If you have a question, stupid or not, I promise you the rest of the room has the same question. So please feel free when we get to that part to ask your questions. So a couple of things that have been happening lately that may affect some of your clients. Everyone knows about the whole price gouging issue.
Such shit.
Yes, such shit is one good way of explaining it. I'm not allowed to say that in court, but that is how I feel. So, what happened was this. Originally, the price gouging statute was triggered by the wildfire emergency. The wildfire emergency was enacted by the governor, Comrade Newsom. And he made it extend till July 1st. He made it extend till July 1st. July 1st came and passed. He didn't extend it. Awesome. The county of LA, whose emergency also exists and who has their own also emergency ordinance, which is based on the state one, they did extend it for a month.
That's
And
Comrade Bass.
Till July.
no, so that Comrade Bass is the city of Los Angeles, right? This is the four. There's four Comradettes on the board, and there's one okay lady. So they extended it for a month, and they can only extend it by 30 days each time. They have given their essentially intent to continue to extend it a month at a time, until God knows when, right?
Further notice.
Pretty much, that's what they're going to do.
Indefinitely.
Indefinitely. However, it's not indefinitely. They can just extend it a month at a time as long.
5 more years.
COVID was that long, and I mean, COVID was pretty much over. The effects of it were pretty much over by September of 2021, and the emergencies in LA lasted until January 23, and then in the outside county until March of 23. So their definition of an emergency is very, very loose indeed. However, I do have solutions for you this one time. Initially, there was a very simple solution, and that's that in the price gouging statute, Penal Code 396, they define the word housing. And they say that you're not allowed to raise the rent by more than 10% on housing. What is housing? They said housing doesn't count for any lease that's longer than a year. So in order to be housing, has to be a lease that's 1 year or less. So everyone said, no problem. If I just lease it for 367 days instead of 365 days, I'm good. Everyone said that a little too loud. Governor Newsom heard about it and said, I'm suspending that definition of housing. Housing now applies to housing of any length of tenancy, doesn't matter. So, ruined the whole party. Thing is, that suspension only lasted until July 1st. That suspension of that definition expired on July 1st. Now the definition is back. Now the loophole is back.
But you can just do it again.
He can, but if he hasn't already extended it, the likelihood that he's going to go in and start messing around with it right now is very, very low. On top of which, take into account that Newsom is setting himself up for a presidential run, and he is trying. Yes.
When?
When?
Next election.
Really?
Yeah. Elections are every 4 years.
Are they?
So, yeah, we do this and we do civics class as well. It's really fun. So, just kidding. All right.
What about improv?
Improv?
Yeah.
We do a little bit of that too. That's a different class. So anyway, The state statute has the definition of housing, which is now back to being for 1 year or less. The county ordinance says that if it doesn't redefine a term, it has the same term it is in the state statute. They don't redefine the term housing. So whether you're in the county or you're anywhere else in the state, at this juncture, well, anywhere else in the state you don't have an emergency, but inside the county of LA, even though we have the emergency, just make the leases longer than a year, and until they change the definition of housing, which that they can do at any time, but they haven't done it, for right now, at least as we sit here today, that's how you get around it. Yes, and on top of which, there's also another thing that applies even if they change the definition of housing, which is that if you do maintenance work, which is more than just wear and tear, more than just fixing the wear and tear. So it doesn't count if you're painting the walls or changing a carpet. But if you actually do repairs between one tenant to the next, say you put in, an old tenant leaves who's been there since 1990, and now you need to do some serious upgrades to the unit to make it ready, you can take that amount of money that you spent, call it $20,000, you amortize it over the lease, we'll call it $24,000 for easy math, that's an extra $2,000. So now you can do 10% above what the last person was paying, plus the $2,000, right? And so that usually gets you further enough above market where the price gouging statute really doesn't affect you very much. Question?
In the unlikely scenario that they do and change it back.
Yeah.
Put that back in, but you have a lease that you've created that's 367 days.
Right now.
Right now.
Correct.
If they were to change it, do you then become
Illegal?
to it?
No, because laws actually have that exact case going on with someone who did a lease before the governor changed it back in March. And they did their lease in February. Laws are not retroactive unless the law itself says we are affirmatively making this retroactive. And the problem if they do that is that they would take a contract that was legal on the day it was signed and make it illegal. There are certain defenses to that that get into constitutional issues. Super illegal for them to do it? Potentially. Yeah, super messed up, but not necessarily super illegal. It gets into very complicated constitutional issues which are far beyond the scope of today's talk. But yeah, generally speaking, they're not going to make things retroactive. And so then your lease, if it was legal on the day it was signed, should be good to go. Any other questions about price gouging? No? Okay. Your houses that you deal with, well, tell me a little bit. Do you guys do mostly single family? Do you guys do mostly multifamily?
That makes money.
Everything that makes money?
Yeah, we do everything.
So,
A lot of high end.
so we do cocaine, hookers, everything?
Exactly.
No,
That's why I'm saying.
pertaining to real estate.
Pertaining to real estate only, okay. So that's not everything that makes money.
In real estate.
Okay, good.
Family mainly.
You're saying single family mainly? Okay. So, and in city of LA, city of Beverly Hills, all around?
Yep.
West Hollywood?
All over.
Okay. So for the most part, not a lot changes in your business in terms of the buying and the selling. Really where you have lots of changes in the law is when it comes to leasing. And where there are a lot of changes, for example, is in the city of LA. City of LA 2 years ago imposed something called the just cause eviction ordinance. And that made it very difficult to start evicting people even from single family homes. Because before in LA, if you had a single family home, you had no rent control. There was no rent control on you, there was no eviction control on you, and even the state law that passed exempted single family homes as long as you give them this little notice that is one of the forms in the car forms, right? And by the way, if you guys are doing leasing, common mistake I see real estate brokers make is that they add the just cause eviction, the rider, the addendum, and they don't check the box in the middle. The box in the middle on the car form is the one that says this house is exempt from California rent and eviction control because it's a single family home and it's not owned by a REIT or a corporation, etc. If you don't check the box, what you are doing is telling the tenant that the house is subject to the California rent and eviction control. And you have now essentially subjected your client to a whole bunch of restrictive laws that they shouldn't be subjected to at all. So be very, very careful when you're adding that to a lease that you check that box. And that one little X makes all the difference.
Only single family, not a townhouse or a condo?
No, it's anything that's separately alienable. So if it's a condo, if it's a townhouse, and it's not owned by a corporation, REIT. So a lot of people say it like, oh, real estate investment trust. That just means, John and Esther's trust of 1990. That's not what that means. It's a REIT. If you're representing a REIT, you know you're representing a REIT, right? So, exactly. So,
Corporation, like I have a corporation? Is that-
correct. A corporation cannot, and it can't be an LLC that has a corporation as a member. So an LLC, totally fine. Partnership, totally fine. Trust, fine. It just can't be a corporation. Stupid rule.
Corporation, you're part of that law.
Your single-family home will not be exempt from the California rent control. All right, and so that becomes a big problem in places where the local law exempts you from the local rent and or eviction control. For example, Beverly Hills, single-family homes are just period exempt, no notice needed. But if you don't give that notice, or if you don't put the house into an ownership structure that is not one of those that are prohibited, then your single-family home is going to be subject to that California and eviction control, and you really don't want that.
Can you go over the California eviction control?
Sure. So that's also known as the Tenant Protection Act of 2019, also known as AB 1482. So back 5 years ago, they passed this law, and it made the entire state now subject to rent and eviction controls if you're pretty much doing rental housing in the state of California. Now, there are certain exemptions. One of them is what we just talked about, is the single-family home. Another is if the property is less than 15 years old. That 15 years is measured on a rolling 15 years, which means that it's just 15 years from whatever day you happen to be on. And it goes by the C of O date. So if your C of O date is more than 15 years ago, then your house or your multifamily building is certainly going to be subject to AB 1482. Now, what that does is it restricts the reasons you can evict someone from the property, and it also restricts how much of a rent increase you can give. If your rent increase is effective from August 1st to July 31st of 2026, the rent increase in the in the LA area is going to be 8% for that time period.
August 1st when?
August 1st of this year.
Oh,
Any rent increase you give now is going to be at least August 1st because it's already July 8th.
right.
And 30 days is the minimum. So pretty much from now on, it's 8%.
Beverly Hills?
So it's the entire LA County area
Wait, so but it's only
if the property is subject to AB 1482.
15 years old or older.
Has to be 15 years older, right? It's only applies to single-family homes.
so
Brand new construction
Yeah.
doesn't apply.
okay.
Yeah.
And what exactly does this rule say again? Sorry.
It says lots of things, but it limits the reasons you can kick someone out. So, for example, a lot of people take your single-family homes for an example. Let's say you didn't give the notice, right? Or let's say you have a property that has a single-family home and a back house on it, an ADU. That's not a single-family home. If you can rent both structures out to separate people, that's called a duplex. I don't care if they're a mile away from each other. I don't care if the main house is 27,000 square feet and the back house is 2,500 square feet and it's a big, beautiful mansion. It doesn't matter. If it's rented to two different people, that's called a duplex.
Okay.
Right? Now, if you have a duplex and it's more than 15 years old, now you cannot just come to the person who's at the end of their one-year lease and say, bye-bye, you got to go. You can't do that.
Okay.
What can you do?
Well, you can kick them out for non-payment of rent. You can kick them out for breaching the lease terms, a material breach.
Would it be mature?
But their contract has expired, so they can just
Doesn't matter.
stay now?
Month to month.
They're month to month now.
But you bring it up 8% at that point, right?
You can bring it up
If
8%.
they don't
Yeah,
want to
what-
pay that, then
Yeah.
Then,
gone.
then they end up not paying you, and you end up evicting them for failing to pay the rent. But you're not evicting them because the lease is over. Question.
When you create an ADU, because the 15 years is based off of C of O, do you get 15, does it work if the ADU is brand new, so that's a new structure?
Good question.
Very good question. What ends up happening is your front house, which is more than 15 years old, is under the law, and your ADU is not.
So
This happens a lot in City of LA.
if you give them notice,
Yeah.
how many weeks do you have to, then can you start the eviction process? 15 years or older?
If it's 15 years or older, you cannot just give them notice for no reason.
No, you give them notice, sorry. You've given them the update that, you give them the notice with the EV, what's it called, with the
You give them, okay, oh, so you're saying, let's say we exempted it.
Yeah,
Okay, if we exempted the house, true single-family home,
yeah.
okay, and now we
And 50
exempted
years
it.
or older.
Well, again, if it's a single-family home, it doesn't matter if it's 15 years or older
Okay, yeah, right.
if we gave them the notice.
Just matter if you do that, right? The notice
Exactly.
Has to be on, remind us all again?
Has to be what?
Has to be on, what form do you have to use?
There's a form called the Just Cause Eviction Form. It's one of the car forms.
Right.
And it'll say there, this property is subject or this property is not
I'm
subject.
sorry, I
The-
was actually asking for the rate increase. What do you have to, what form? do you-
Oh, so that's just a 30-day notice of rent increase.
Okay.
Yeah.
And then at that point, if they don't pay,
Don't pay the rent.
then you do the form you're talking about.
Correct. So now we're talking about how does an eviction work?
Yeah.
Fine. So the way an eviction works is like this. All evictions start with some kind of a notice. In the case of pay or quits, in other words, a notice to pay or quit, that means,
Not on my phone.
sure, a 3-day notice to either give me my money or leave. That's usually on a 3-day notice form. It's 3 court days, not calendar days. If you've never done one before, this is not the time to learn. Let us figure it out for you, because there are a multitude of ways to mess up 3-day notices. And sometimes the courts will say, well, this isn't difficult enough. Let's add another level that isn't even in the law, like they did a couple weeks ago. A new case came out and said, well, you know, how does the tenant know when the 3 days expires? Even though it says 3 days, not including Saturdays, Sundays, and judicial holidays from the day you're served. And the court said, well, how do they know when it expires?
I don't know.
Because it's not hard to count to 3, but apparently for some people it is. And they said, no, it has to be on the form somehow for them to figure out when it expires. So now everyone is freaking out, and you really do have to write the day you served it as well. Because then all the information they need to count to 3 is on the form. So let's see how that works in a real life example. 4th of July was on a Friday this year, right? Let's say you gave a notice on July 2nd in a lease that had no grace period, right? They didn't pay the rent on July 1st, July 2nd, you hit them with a 3-day notice.
7th would have been the 7-day notice, the 3-day notice, no?
It would have been the expiration?
Expiration.
Probably, yes. Let's do the math, right? The 2nd doesn't count. The 3rd is day 1.
The 2nd doesn't count. The day they're served doesn't count?
The day they're served doesn't count. All right, so the second doesn't count. The 3rd was day 1. 4th of July, court holiday, doesn't count. 5th, Saturday. 6th, Sunday, right? The 7th was day 2. The 8th was day 3. Today would have been the 3rd day, had you served them on July 2nd, all right? That's why they basically make you start putting the day that you served it. That's a brand new rule. The Court of Appeal made it up, but now everyone pretty much has to comply with it, unfortunately. So that's why you don't necessarily want to do the notices yourselves if you're managing a property or if you're trying to assist a client. This isn't something you want to just do as a hobby. It's not fun. So don't mess things up. Call us.
I'm still a little bit confused.
Okay.
You said, because I wasn't following the whole time.
All right.
It's kind of day drifting, but, so basically, automatically, a lease turns into month to month.
Yeah.
And you can't basically say, okay, the lease is expired, we found someone new, leave, unless.
It's
like,
exempt.
What does that law pertain to? It pertains to 15-year-old homes?
It pertains to, let's go through it again,
Yeah.
for things that will actually apply to you. It either applies to multifamily, 2 units or more,
Okay.
that is more than 15 years old.
Okay, but new construction, it does not.
So it doesn't apply to anything that is less than 15 years old.
Oh, okay. Okay, got it.
Right.
They could kick you out after a year if it's less than 15 years old.
Well, then it depends on what city you're in.
LA, let's say.
If you're in the city of LA, you have a local eviction law called the Just Cause Eviction Ordinance. That law applies to all the property in LA that is not already under the Rent Stabilization Ordinance. And so it doesn't matter if your C of O was this morning. As soon as you open up for business, your building is subject to the JCO. And it includes single-family homes. There's no exemption for that.
So basically everyone.
Yep,
Okay, so basically I never have to re-sign a lease. I could just say, hey, I'm staying here.
correct. And as long as you continue to pay the rent,
Okay.
don't burn the place down, don't cause a nuisance, you can pretty much stay in there
But they-
forever.
But they can't increase the rent.
They can increase the
And
rent.
if you don't pay, like the increase, that's where, okay, got it.
If you don't like the
Start
increase,
process.
correct. If you don't like the increase, in LA, there's a special little caveat. If they increase you more than 8%,
So it
you can
jumped from
leave
3
and they have to
8.
pay you relocation for that.
It jumped from 3 to 8?
Wait, what?
No, no, no. Okay. Hold on. Let's back up.
Oh, my what?
Lots of questions. Lots of questions. And technically, I only represent landlords. So if you happen to be a tenant and you're taking this advice to go screw over a
No,
landlord,
God forbid, are you
Okay.
crazy?
yeah, I take no responsibility for that. So let's back up for a second. LA gets very confusing, okay? So first of all, we have to know that in LA, they have this stupid thing called the JCO, Just Cause Eviction Ordinance. It applies to all of the property that is not already RSO. RSO stands for Rent Stabilization Ordinance or rent control. Rent control, the old version, only applies to properties that are built before October 1st, 1978 and exempt single-family homes. Completely. No notice needed. If you're a single-family home, you're just exempt. It has rent and eviction control inside of it. That's the RSO. Yeah? Okay, good. Now the JCO comes. The JCO has no rent control component, meaning it doesn't have anything in it about how much you can or cannot raise the rent. So if you have a single family home in the city of Los Angeles, you can still raise the rent however much you want. Price gouging statute notwithstanding. Like, let's just say no emergency, right? You can theoretically raise the rent as much as you want. Question is, what can you evict somebody for? And that's what the JCO covers. The JCO, unlike the state eviction statute, does not exempt new construction. It does not exempt single-family homes. In fact, it exempts virtually nothing, right? Hotels and motels and a whole bunch of other stuff that you're never going to run into. So other than those things, every rental property in the city of LA is either under the RSO because it's in an old apartment building, or it's JCO because it's not in an old apartment building. Clear? Right. Under the JCO, you also cannot evict someone just because their lease ran out. Now, let's say you're renting your house. You want to come back to your own house, right? You went on your 1-year vacation, you know, got to see all the different Carnival cruise lines, and now you want to come home. What do? Well, you have to go through a whole process. Well, first you have to call me because you're going to mess this up. And second, what we do is we go through this process where we have to complete a declaration. We have to complete a 60-day notice. We have to serve that on the city. We have to pay the city a fee. Then we have to serve that on the tenant and with the declaration and the 60-day notice. And then after 60 days, you might have to pay them a relocation fee. Okay?
That's called cash for keys, right?
No, it's not.
It's not?
No, it's not.
Okay.
Yeah. Got to stop daydreaming.
I'm not
No, just kidding.
Actually, I do.
Yeah, we know.
The psychic show is after this one. So you give them the 60-day notice. Now, there are certain circumstances if it's a real single-family home and if the owner doesn't own more than 4 units other than the single-family home, then all they'll have to do is pay 1 month of rent as the relocation, which we do as a credit on the second half of the 60 days. If they do own more than 4 units, they have to pay relocation. So, and that relocation can be anywhere from $10 to all the way up to $25,000.
There is a cap or
Up, say again?
is there a cap on it?
Yeah, right now it's somewhere between $10 and a little over $25,000
Is
because
that prorated off like your rent, or how does it
no,
come
these
up
are
with
just
that
flat
number?
fees.
Oh.
Doesn't matter what rent you're paying. Yeah. Yeah, those are the relocation fees. And those same relocation fees apply to any no fault eviction that you do in the city of Los Angeles. And when I say that, I want to be very clear. A lot of people confuse the city of Los Angeles. with the County of Los Angeles. They think those are the same thing. They're not. The City of Los Angeles, I always use the pepperoni pizza example. Think of the county as one big pepperoni pizza, right? Now, on the pepperoni pizza, you have pieces of pepperoni, right? And they're all separate from each other. At least in a good pizza, that's the way they're supposed to be, right? Each of those is like a city inside the county. And in between the pepperonis, you have just the cheese. If you're on just the cheese, that means you're outside of an incorporated city. You are in the unincorporated part of County of Los Angeles. If you're on a pepperoni, that means you're inside of an incorporated city. And generally speaking, the county, unincorporated county rules will not apply to you, except, of course, in the event of an emergency, in which case they do apply to you, right? So that's generally how it works. So you need to know what city you're dealing with in order to understand what laws apply to you. What happens if you are here on the border between Beverly Hills and West Hollywood, or you're on the border between Beverly Hills and LA? It's just a few blocks from here, right? You actually have to go and look up your address on the county website, because your mailing address might say LA, you're actually in Beverly Hills. Lucky you. Your mailing address might say West Hollywood, you're actually in City of LA. You really need to know what you're dealing with in order to be able to analyze what your obligations are. Because in Beverly Hills, the rent control is very different than it is in LA, which is different than it is in West Hollywood, which is different than it is in Santa Monica, which is also different than it is in unincorporated county. And you could be in one or the other if you're on this side of the street or that side of the street. So it's very important to know what city you're dealing with, especially if you're going to tell people, oh, these are the laws in your city. Okay?
A lot of nuances here.
She said, call me.
Exactly.
All new,
What?
for sure.
Call me, yeah.
That is the
You're
moral.
saying it's all great, and it's like really valuable for me to see like how, difficult this process is and how you could easily contradict yourself by saying one thing.
Yeah.
So this is amazing.
So the moral of the story
I'm not
is,
retaining too much, so I'm just gonna say, call me.
give this man a prize.
Yes, sir.
He has understood the point of the whole
Let's
speech.
fucking go, baby. Let's go.
That's it.
But you only do landlords.
I only do landlords. Got to pick a team.
So,
Question.
just because the cash for keys made me think about it.
Sure.
If you get into a situation where it is inevitable, I call you and you're like, hey, Ty, this is inevitable that you're going to end up paying a relocation
Right.
because you can see down that road.
Sure.
Does it make sense to just travel the road, or does it make sense to go and try and pay them off less?
Cash for keys is always the best. You don't always get to pay less. For example, in Santa Monica, a cash for keys for less than you would otherwise pay them is illegal, unlawful. It's unenforceable. You can sign it all day long. It doesn't matter. Right? But in LA and West Hollywood, you can. You can negotiate whatever price you want. And that's what a cash for keys is, by the way. A cash for keys agreement is a voluntary agreement between you and the tenant where you negotiate two numbers. What day are you leaving, and how much money am I paying you? There are other terms like when am I paying you, how much am I advancing you, et cetera, et cetera. But generally speaking, those are the two numbers that we would need in order to prepare your cash for keys agreement. Right? Now, why can't you just make an agreement on your own? Why? Because every city has their own cash for keys ordinance, which requires you to give certain notices to the tenant in order for the cash for keys agreement to be valid. And each of those cities requires slightly different language. And the language has to be in a slightly different place. Most places have it where it has to be above where the signatures are in 12-point font. I'm not joking. That's literally one of the requirements, right? So again, moral of the story being, don't try this at home. Call us. This is what we do, and we can help out your clients to not get in trouble, right? Any other questions? And it doesn't have to be about landlord-tenant. It can just be about general real estate law. Our firm is a full-service firm. We handle real estate matters.
I have a question.
Sure.
Only because it keeps coming up. This BRBC, so there is a fine line between it not meeting compliance and the law actually not allowing the agent to keep the commission. Have we gotten closer to them saying that they will in fact withhold the commission if it's done correctly, or this is still something that's still up in the air?
I think it's still up in the air.
Talking about it.
I think all that stuff is still up in the air.
Okay.
Yeah, as far as I know. I mean, I don't,
Because our compliance department is cracking down harder,
right,
but I always end it with, but are we still getting paid?
right.
And so far, everybody says yes, but there seems to be like a hanging deadline of how long we have till that actually happens.
I think it's still up in the air, as far as I know. Yeah.
I have
Yeah.
a question, because I have a purchase going on,
Mhm.
potential. If you're gonna crowdsource a sale, does that have to be, do you need just an EIN number, or do you have to be like Reg C? Like, do you have to submit like that property for it to be crowdsourced? Or
You-
crowdsource funded?
Crowdsource funded. So you are going to go out and raise a fund in order to buy an investment property.
Yeah, or he's gonna put it out on a platform
Mhm.
where you're going to fractionalize the ownership of it.
Right.
Yeah.
That's interesting. I think that gets more into securities laws,
Securities laws.
where I'm not really an expert.
Okay.
It sounds interesting and very, very risky.
Sounds terrible. You should run away from it.
Well,
Yeah.
not really.
Listen, if you're the seller, if the money comes in, it doesn't matter to you.
Right.
Money's money.
Yeah.
That sounds like more of a buyer problem.
Right. Yeah, I guess so. But I guess as an agent, if we facilitate that sale, and it goes through escrow.
Right.
Later on, there's some disgruntled deed holders. I guess anyone could be sued, right?
Anybody, the American rule is that anybody can sue you for anything at any time for any reason.
Disclose.
Yeah.
Maybe that'll set you free. I don't know.
Yeah, I mean, I'm not exactly sure what one of the investors in the investment would sue the agent for.
Right.
That would be kind of difficult because they wouldn't have independent standing.
Right.
They would have to force the buyer entity to sue you as the agent. So that would be a little harder for them and a lot easier for us to defend. But in terms of what does the buyer have to do to be in line with the securities regulations, to be honest, I can't really comment on it. It's not my wheelhouse, as they say.
Well, I have a rental that I rented.
Okay.
And
Where?
And then within 2 weeks you have to give a notice of all the anything in the property that was deemed to be a write-off, or like if anything was messed up, right? So you have to put that in writing, and you have to actually send it via mail
Within 2 weeks of the time they move in?
out.
Oh, out. You're talking
Yeah.
about a security deposit.
security
Ah,
deposit, sorry.
that's a different issue.
Yeah.
Okay, fine. Let's talk about that.
Something like that.
What
Those are
happens?
always
And
so
then-
fun.
And
Yeah.
then So the time that they move out, you have to send a list of everything, like the rugs, everything they ruined.
No. It's a lot more complicated than that.
All right.
They changed the rules on that too. So, starting actually July, if you are going to rent a property, you have to take pictures of the property 4 times.
What do you mean 4 times?
It's the number after 3 and before
So the same
5.
picture 4 times?
What?
I don't get it. What does that mean? The same
He'll explain.
picture 4
Once a
times?
quarter to show the wear and tear, if there is any, I would assume.
No. But that's a good try.
I gotta throw something in the hat. Come on.
So you're gonna take pictures 4 times. Once is before the tenant moves in, like right before the tenant moves in, to show how the property looked at the time you gave it to the tenant. 2, right before they're gonna move out, generally speaking, you have to give the tenant a notice saying, do you want to have an inspection so I can tell you what I think is wrong with the unit and you have a little bit of time to fix it before you go so that I don't have to take it out of your security deposit. That's 2 weeks before they move out. At that time of doing the inspection, you're going to take pictures of the apartment or the house. Now, the first time you got to take pictures of the whole house. And the way I recommend you do that is 4 walls, ceiling, and roof. If you take every room, all 6 of those directions, you should be covering the whole house. All right?
Is video okay?
Video is fine. It's, a little harder to manipulate and use, but you'll see in a second that it's technically okay. And technically a video is just thousands and thousands of pictures. So I think it's okay. It certainly does not say you're not allowed to use video. So You take the pictures or the video the 2 weeks before they move out, if they want the inspection. If they don't ask for the inspection, you're not going to take pictures because there's not going to be an inspection. The third time you're going to take the pictures is after they move out, but before you make the repairs, so that you can show, all right, I gave them an opportunity, or they waived their opportunity to have the inspection. This is everything that is messed up. I'm taking pictures of everything that's broken that I'm going to fix. And then you take pictures again after you've fixed it. All those 4 sets of pictures can be delivered to the tenant. You only have to give it to them once they move out in their security deposit letter. That's the notice you were talking about. And it's actually 21 days after they move out. And so you give them a letter. The letter itself has to be mailed. It can be emailed as well, but you didn't do anything. If you emailed them, all you did was you sent them a courtesy. In order to be code compliant, it needs to be mailed. The pictures or the video do not need to be mailed.
What if it's not mailed?
What if it's not mailed?
Yeah.
Technically, you didn't comply with the code.
You just give them a courtesy notice.
Well, hold on one second. So the pictures and the video can be delivered on a thumb drive, or you can just send them a link. And that can be in the letter itself. Well, generally, yeah, it's going to have to be in the letter itself, or you can attach to the letter a thumb drive. One way or another, you do not ever have to print out the pictures or, I don't know, put the video on film or anything like that. And if they don't know how to access that, well, you know, too bad for you. You know, okay, boomer, as they say. So that's pretty much how you do the security deposit notice. Now, you asked what happens if you don't mail it, what happens if you miss the deadline. It's not the end of the world. Okay, a lot of people say, oh, I sent it on 23rd day. Okay, it's not the end of the world. What you're losing is the right to your ability to self-help keep the deposit. So technically speaking, you owe the deposit back to the tenant. It does not waive your right to claim from the tenant the damages that they incurred. So say you had a $5,000 deposit and you had $25,000 worth of damages, they could come and sue you in small claims and say, hey, I want my $5,000 back. You say, okay, here's my cross complaint for $25,000. So you now still owe me $20 as a net offset. So did you really lose anything? Not really, right? The one problem is that if you withhold any part of the security deposit in bad faith, they can get what's called treble damages. That means they can triple what you owe them.
What's considered bad faith?
Bad faith means you are withholding for no good reason.
Oh, right.
Then they'd have to prove that.
Correct. What?
What about the damages that are considered wear and tear?
Wear and tear is excluded. So, and the amount of wear and tear really depends on how long they were living there. So, for example, you rent someone a unit for 1 year. You come in and their ESA dog decided to use the carpet as their own personal bathroom pretty much every day that year. That's not normal wear and tear. That's just disgusting nonsense. And so fixing that carpet or getting rid of that carpet is, you can deduct for that. Same example, carpet is all messed up, maybe not as bad as I just said, but 20 years later, because the guy moved in 20 years ago, it's going to be very hard to claim the amount for fixing the carpet because it's a 20-year-old carpet.
Especially with carpet, though, isn't there a rule that the landlord actually has to change it out every 2-3 years or something like
Some places yes, some places no. West Hollywood, you have to do certain painting and certain carpet changes. They're very concerned with these kinds of things because you know this is the most important things in people's lives is carpets and the paint outside your old apartment building. But yeah, in LA, that's not a requirement.
So our broker just told me, I just did a lease.
Yeah,
They have a pet. The tenant has a pet.
Yeah.
They wanted a pet, the owner wanted a pet deposit.
yeah,
And the broker said not to make it a separate line item pet deposit because they're in an issue where somebody claimed damages from the dog
yeah,
and then they're in court and the judge said you have to give them their pet deposit back,
right.
but you can take the damages out of the security deposit.
That's probably a good way of
So
looking
they
at
said
it.
Just don't line
How much
item
was the
it.
pet deposit?
Are you allowed to take a pet deposit anymore?
So I think what you're asking about is the rule about taking more than 1 month's rent, 1 month's rent as the security deposit. So that's another new rule that they made.
That was
That's
the
only
issue,
1
was that it
month's
becomes
rent,
more
right?
than 1 month's rent.
Exactly.
So
So
1 month's rent.
Even for furnished places, right? It's not 1 month.
Correct. It's 1 month unless you qualify for an exemption, which means that you can't own more than 4 units in 2 buildings. So if that's you, then you can take 2 months. But for everyone else, it's 1 month. Yeah.
Is it?
Yeah. For everyone else, it's 1 month. It doesn't matter what you call it. Doesn't mean half of it's security, half of it's pet. It literally doesn't matter.
So then what happens, so then, if you take more than a month, now what? So then this owner did take more than, they took $500 pet deposit on top of the 1 month, so it's more than a month.
So I mean, the $500 they have to return, no questions asked. But again, theoretically speaking, if you have more damage than the deposit plus the pet deposit, you still get to offset.
But legal, they're fine, they don't need to do anything different in terms of like legal.
There isn't really much in the way of a penalty in the new law. No. It's not that I suggest you break it, but if you do, not the end of the world. Yeah.
Okay, I have a question.
Yeah.
We'll segue from rent to buy, rent to own.
Rent to
Done
own.
rent to owns and options to buy.
Sure.
I think today it's an interesting market because sellers are having a tough time getting their price. Buyers
Sure.
have cash.
Yeah.
And they want to not put all their cash in one place. They want to hold on to their capital. But they're willing to rent a property
Yep.
and apply, like they like to apply, it's negotiable, their rent money towards the purchase price.
No problem.
And then they would like to lock in a future value.
Sure.
To say, I'm going to rent the house for 7 years. I'm going to give you consideration. This is how I see it. I'm going to give you consideration to lock in that price.
Right.
If it's a $10 million home, I'm going to give you $10 million. I'm going to a purchase price of $10 million. I'm going to give you 3% and your deposit. Can it be more than that for an option? Or does it have to be more than that for consideration?
Right, so
and then you have to release the money at some point.
No, so what you're talking about right now is a completely separate contract. It's the option contract.
Yeah.
Has nothing to do with the security deposit. It really has nothing to do with the rent.
Oh, no, I'm saying option. Okay. Right.
Exactly. So rent to own is the colloquial term that we give to what amounts to an options contract, right? It's you are buying the right to lock in, as Ben said, a price and the right to buy the property according to the terms of the option contract. So that might be you have 3 years to exercise, 5 years to exercise, 10 years, whatever it is. If you exercise in the proper way that it provides in the options contract and you give the money at the time that it says you're supposed to give the money, then you get to buy the house. A lot of the times what people will do is they'll actually negotiate the entire purchase contract in advance. And they'll say, okay, here is the purchase contract.
Right.
Here's a copy of it attached to the options contract. The options contract says at any time within X number of years, as long as you pay Y number of dollars, you can come and effectuate this purchase contract. And here's what we're going to do when you execute. We're going to close in 60 days. You're not going to have any contingencies because you've been living in the house. Or you'll have contingencies, whatever it is that you want to do. None of the laws that we've been talking about today that pertain to landlord-tenant relationships apply to the optionor, optionee, seller-buyer relationship. So thankfully, the local entities and the landlord-tenant laws really don't get involved in the purchase and sale area. It's just a completely different relationship.
Lease agreement, and then you attach a purchase agreement.
You have the lease agreement, and then you have the options contract and purchase agreement separately. You can reference them, and you can say, hey, I'm only doing this lease with you if you sign the options contract. It's usually something that the buyer, or in this case, the tenant, really wants, right? Because for the seller, if he's already doing a lease and he's taking the risk that someone's not going to buy it, why would he want to lock himself into a purchase price? This is really a benefit to the tenant/buyer, right? So, and you can charge them whatever option price you want, and you just negotiate that as being the option price.
Price you can.
Pretty much.
Okay, but isn't there a rule in California if they don't execute on this, effectuate the sale, then only 3% can be released, or is it different?
No. You're talking about liquidated damages.
Yeah.
Okay, completely separate thing.
The option, it can be 10%, doesn't matter.
Exactly. So it's whatever you negotiate. Remember that the person, what they're doing is they're buying an interest in your real estate. They are, in fact, if you're representing a buyer, again, please hire a lawyer to do this, because the proper way to do this, to make sure that the seller doesn't sell the property underneath the
Right.
buyer, is to record a memorandum of the option. It doesn't mean you record the whole agreement. You just record a separate document that it's like a 1 or 2 page document that is notarized. You record it on the property, and then that option will now flow with the property. And
A first right of refusal too, don't
that's
they?
exactly what it is,
Oh, that's smart.
right? Well, actually, no. It's not necessarily a first right of refusal unless it says it is.
Right,
But
you
the,
make it,
but
you're supposed to, right, make a first.
theoretically, you're supposed to. But at the end of the day, you really don't care. If you have the option to buy it at any time, the house, if in 7 years, the house can change hands as many times as you want. Whoever's buying it is buying it subject to that option if you record it. And then at the end of the 7 years, you say, I get to buy it now. And if you paid $14 million for the house, but my option is $10 million, guess what? You just lost $4 million. You're required to sell it to me because you bought it subject to that. Let's just say someone does your example. I lease a house, and together with my lease, I negotiate an option to purchase the house for $10 million as long as I execute the option sometime in the next 7 years. And for this privilege, the seller, let's say, charges me $500,000. $500,000 is now non-refundable, right? We can negotiate to make it applicable to the purchase price, or we can just say, this is just the price for the option. It's my money. You are paying for this right. You can execute, not execute. That's up to you, but this is my money. I get to keep this. Okay.
What if they stop paying rent or something like that?
So again, you have to write the options contract such that it's only good so long as the lease is good. Again, there's a lot of complications here. You have to not be in default on the lease in order for the option to be good. So you have to sort of combine them and,
Okay.
make them, cross-referenced and all that jazz. But let's just say they're not, right? They're paying their lease consistently. And the guy who negotiated the contract as the seller, he now sells the house to guy B, who sells for $11 million. And he then sells it to guy C. And he then sells it to guy D, to the point where guy D has now paid $14 million for this house, right? He didn't come to me. He didn't come to a lawyer. He didn't check the title. He didn't care. He says, $14 million, very nice house. Here's your money. Okay. I like having this house and I like having the rent. Because remember, the guy's still there. The tenant's still there. At the end of the 7 years, as long as he exercises it according to the terms of the option, he can come to guy D, who paid $14 million, and say, I'm going to buy the house now for $10 million. Here's my option.
But he can exercise the contract at any time.
At any time, but if he has 7 years, he might take the 7 years. He's locked in the price.
This is probably the most sense you've made all day today because I do options trading on stock.
That's exactly what it
It's
is.
like you have your strike, you have your expiration.
That's exactly what it is.
Straightforward, I can exercise it at any time.
That's exactly what it
Whether
is.
it's in the money or out of the money.
And if
There
they
you go.
walk, they lose their option money.
And if they what?
And if they walk, they lose their option.
They would lose that
Correct.
500,000 strike price.
Correct. The option premium or the option consideration, whatever name you want to give to it.
You have the right to exercise that contract to someone else?
If your option says that you can,
Oh, yeah, it's
great.
all-
If the option says it's non-assignable, then it's not assignable. With an options contract, you can pretty much do kind of whatever you want. Yeah. So, yeah. Any other questions? Are there any questions from the board? Or are these all just AI bots? Everyone's just taking notes?
I have a question.
Yeah.
A couple years ago, I heard that the city of LA was trying to get rid of homeowners' ability to do background checks on their potential tenants.
Yeah.
Are they still trying to do that?
I'm sure they're trying to do all sorts of fun communist
If-
things,
if they-
but they have not yet.
And if they do succeed in doing that, like, what can a landlord do in order to figure out if the potential tenant is a
Bad person?
yeah?
Okay. So on the state level, they also tried to do this where you can't check criminal backgrounds, or some people will tell you, like for FHA purposes, that you're not allowed to say no to a person just because they have a criminal background if the criminal background is not somehow material to the landlord-tenant relationship. That's a suggestion. that's just something fair housing people say to, because HUD technically says, oh, that's our suggestion. Nonsense. There is no law that says you're not allowed to say no to someone because they have a criminal background. To the extent that they started to make a law like that, to be honest with you, check their background anyway. And then if they ask you, why did you deny me? We're going to go back. Don't deny them. Don't say yes either. It's called ghosting. Okay? Girls in LA invented this, and you can apply it to real estate just like you can apply it in dating. All the girls are like smiling. They're like, yeah, I've ghosted a few guys. Well, just like you can ghost a few guys, you can also ghost a few tenants. There is actually no law that says you have to tell them yes or no. The only time you have to tell a tenant why you denied them is if you deny them because of a credit check. But that's not the only reason you can deny someone. You can also deny someone for a lot of perfectly legal reasons that have to do with their inability to show legal income, the fact that they have a judicial record. That's not necessarily tied to their credit score.
Which judicial?
Judicial? Having to do with the judicial system.
Okay.
Means they have judgments against them,
Yeah.
right? Or they have a bankruptcy. Maybe you see that they're just very, very litigious people. They sue every landlord they ever come into contact with. That's an economic reason not to rent to someone, and you are allowed to not rent to people for economic reasons. You do not have to rent to every Joe Schmo who comes into your rental office and makes an application and says, I'm going to sue you if you don't give me the apartment. It's just not true. So, but if you are want to say no to someone, and it's just because you feel like they're a bad guy, or there's something else going on in your mind that is not exactly legal. You're discriminating on something that probably should be legal but isn't, right? Just don't respond. Simple as that.
I think Esther has a question. Esther, go ahead.
Yeah.
Yes, hi. Can you refuse someone that wants to rent, like Section 8?
Oh, very good question. That's the next thing I was going to talk about. All right. Section 8. Very, very.
That was a good question.
Yeah, okay. So that's a very, very good question. We'll cover that right now. So here's how it works with Section 8. A few years ago, the state of California passed a law which added source of income as a kind of illegal discrimination. Even though they said source of income, they define it as really kind of any government subsidy, or really just not even a government subsidy. The way that the person makes money, or the way that they pay you the money, you cannot discriminate against them. So in other words, if they come and tell you, I want to pay with Section 8 or this other government subsidy or my church's fund, you cannot say no to them because of that reason.
Literally just got all of those in a text.
Say again?
Literally just got all of those in a text.
Okay, well this is actually, that's probably a scam.
Yeah.
All right?
I'm ghosting. It's fine.
See?
Yeah, because I don't want any part of it.
So the actual, you guys all look very, very young. Have you ever seen the original Ghostbusters? It was in 1983.
Oh yeah.
I did.
Okay.
Old.
Okay.
I'm old. I'm older than you, my friend.
Maybe, maybe not.
He's actually 95.
No, you look awesome for 95, dude. So, in the end of Ghostbusters, right? You remember the guy says to one of the Ghostbusters says to Ray, he says, Ray, if anybody ever asks you if you're a god, you say yes. And that's what you say when someone asks you if you take Section 8. I'm telling you, if someone ever asks you, do you take Section 8? This is the one time you actually don't ghost. You just say yes. It doesn't mean you're taking them. It doesn't mean you're offering them the apartment. All you're doing is saying you do not discriminate based on source of income. But you don't have to say yes to the person. All you're doing is you're saying, I don't discriminate based on that. Try to understand legally what we are talking about. From a legal perspective, not a moral, spiritual, religious, or any other way, saying no, I don't take Section 8 is the legal equivalent of saying, I don't take black people, or I don't take Jews, or I don't take people with children. It is legally the same now. That's how serious it is. So the scam became this. There was a lady, she filed 15 lawsuits in just the 1 month, together with her skeezy lawyers. She would text, she was on Section 8, and she would text agents and landlords who were mom and pop who just didn't know, and say, hey, I'm interested in your unit, do you take Section 8? Never called, always texted, so she had the record. And they would say, no, my client's not interested in Section 8, or I don't want Section 8. And Section 8 is a big pain in the butt. You might not want to take
Say
it.
yes.
What?
You have to say yes.
All you
As
do,
an agent, you can't say anything, right? You say, I'll check with my client, like, I'll check with the client.
don't even say that.
Okay.
Just say yes.
Got it.
Say yes.
Or
You can't
ghost.
ghost.
What?
And you can't ghost right there.
On that particular question, do you take Section 8 or do you take this government subsidy? Yes, we do. Now, do we take you? Maybe not,
That's an important one.
right? But do we take Section 8? Yes.
I think Esther's trying to ask you something.
Yeah.
Esther, go ahead.
Go ahead, Esther. Oh. Wait, sorry, I can't hear you. I can't hear you.
Can you hear me?
Is there any way to raise the volume?
Esther, can you turn your volume up?
Is it TV volume?
I think it's all the way up.
I think it's the TV volume.
Okay.
Shaka
I'll go over here. Yeah, hold on. Go ahead.
Question, the Section 8 cannot take only like for month-to-month basis, right?
Correct.
Okay, so if I tell them my client only do month-to-month, can I say no then?
Correct. So that's another technique that people have used. Very, very good, Esther. Okay. Section 8 will not enter into any leases that are less than a year. Okay? There are also places where you're not allowed to do leases of less than a year. For example, in the city of West Hollywood, you can't do that. You can have your short-term Airbnbs if you have a license, but if you're doing a lease, you're not allowed to do a 6-month lease in the city of West Hollywood. It's just not illegal. It's not legal. You have to do a year. Okay? So this is not something you can try in every city. But City of LA has no such rule. So let's say you're in the city of LA, someone comes to you with Section 8 and they say, I want to rent for Section 8. You could say, no problem. Here's the rent I want. Section 8 says, no problem, we can pay that. You really don't want to take them. You say, no problem, I only do month-to-month leases. You want to sign a month-to-month lease, Section 8, this rent? No problem. En baya, as they say, right? So, Section 8 will then come and say, well, we don't do month-to-month leases. And you say, that sounds like a you problem and not a me problem. You're not rejecting them. You're actually accepting them. Section 8 is the one rejecting you.
Because they only do 12 months.
They only do 12 months. You say, I only do month to month. Okay? Now, it's not a foolproof plan because if you all of a sudden have all the leases in your building are all 1 year and you told just this one Section 8 person that you only do month to month, if that ever comes to light, you're going to be in trouble. Right? But generally speaking, as long as someone doesn't get into all of that stuff, you should be okay. And they'll just be on their way.
What's the issue with taking Section 8 if the government's paying for the rent?
Okay, so you take Section 8, right? They're giving you a nice rent. This person's rent, if they don't pay it, is a very small portion of it. And the government is cutting you the checks
Every month.
every month. Very, very nice. Now try to raise the rent. Right? In order to raise the rent, you need to get Section 8's approval. Let's say you're in a non-rent control building and the maximum you can raise is 8%. Section 8 can say, we did our comps and you can do 2%. You say, what are you talking about? Show me your comps. They'll say, confidential, we can't show you our comps. That's what they say. And you just have to live with it. And you really can't get rid of the person in most places. Right. And Section 8 is generally not going to be in single-family homes. The vast, vast, vast majority of Section 8, especially in the LA area, pretty much all of California, is going to be multifamily. So you can't really cancel the contract. A lot of people say, oh, I'm so smart, I'll come up with this new idea. I'll just cancel my Section 8 contract and the tenant will have to pay all the rent themselves. Really doesn't work in most places, especially not with rent control, because now you're taking the tenant's rent from like $500 to $2,500, and that's an illegal rent increase, right? So generally speaking, if you want to take Section 8, very, very good in terms of guaranteed money, you know, United States.
Question.
Yeah.
When did the rent increase jump from 3% to 8%?
Okay, so that's a different question. Let's talk about that for a second. What we're talking about is local rent control versus state rent control. Okay, local rent control can usurp the state rent control. So the state rent control says if you have a local rent control that's more restrictive, that's the one that applies.
So which is which?
Which is more restrictive?
Yeah, which is,
Always state. I mean, always city.
okay.
The local rent control is virtually almost, well, first of all, if it were less restrictive, then the state one would apply,
Right.
right?
So the city is 8%?
No, the city
city
is
is
3%. City of LA is 3%.
Correct, okay. That's
Right.
what I remember.
Correct. It's 3% starting actually now, starting this year.
Has it
And
always been?
no, last year it was 4%.
Oh, okay, it's coming down?
Yeah.
Lower rent, higher minimum wage.
Yeah, exactly. So it's 3% plus you get 1% extra. This is, again, only applies in the city of LA, what I'm about to tell you now. Then you get 1% extra if you pay their electric and 1% extra if you pay their gas. So the total maximum could be 5. Okay? But
If you pay their utilities.
if you pay those two utilities, for example, if you pay their water, you don't get anything extra. If you pay trash, sewer, cable, internet, doesn't matter. You don't get those extra. It's just electric and gas, right? That rule does not apply, for example, in Beverly Hills, where they also, if I'm not mistaken, don't quote me on this, is also 3%, but you don't get the extra 1%. In that way, Beverly Hills is worse than LA. Question.
Gentleman online,
Yeah.
Harold said, what about Costa Hawkins? If the landlord never had the tenant sign an exemption from the
Sounds
state
awfully
rental
specific.
law AB 1482, can the landlord have the tenant still sign it after the tenant's lived in the property for a few years?
Very good question. It's got nothing to do with Costa Hawkins, but it's a very good question. Yeah, so this happens a lot where they didn't give the exemption. The AB 1482 exemption in a single family home, or maybe, well, actually, in units that are newer than 15 years, you don't have to give an exemption, it's automatic. This really only applies to single family homes, condos, townhomes. So what happens if you forgot? What happens if your agent, not anyone at Revel Real Estate, of course, forgot to sign the box? Yeah, there are ways of adding it. If they're month to month, you give them a 30-day notice and put it on an addendum. If they're still within the year, we try and finagle it a little bit and just send them a 30-day notice anyway. That's pretty much all you can do. And some courts will accept it and some courts won't. We've had it both ways. That's why it's very important to do it at the outset if that's something that you are legally allowed to do because you're renting a single family home. Yeah.
Okay, so we want to put you into motion. So I have a client
Yeah.
that would like to hire to engage with you,
Great.
and he wants to do what I was talking about. And this is anyone in the office. We can all make some money together.
He only
to-
does landlords though.
No, that's not true.
What? Kind of is.
Oh, you only do landlords?
Only landlords.
No, that's it.
Yeah.
I don't represent tenants.
What about purchase?
Tenants ain't got no money to
about-
No, purchase and sale.
Yeah.
Purchase and sale, we represent buyers and sellers.
Great. Yes, you do that.
Yeah, we just don't represent tenants.
Oh, that's okay. Yeah.
Yeah.
Well, what if? Okay, I want to do the purchase and sale agreement. With
Yeah.
An option. So I would like to send a letter of understanding, like an LOI, to other agents who represent sellers, and say I have a client that wants to your property is asking $10 million. We'd like to do a lease for 5 years, and we're going to pay you, 3/4 of the market rent.
Okay.
And we're gonna release 5% the deposit to you. 1% is gonna go to my buyer's agent. 1%
Yeah.
is gonna go to the listing agent, of which anyone in here can split that 1% with me. And if you help me find these people, and then I want to buy the house in 5 years.
Yeah, we could probably handle something like
Do you
that.
think it should be like a letter, just a simple letter that explains the bylaws of what that looks like? I think that's a good way to start.
Yeah, you could do that. I mean, in large transactions, an LOI is usually
Yeah.
what we start with.
Yeah.
You want to make sure that it's non-binding. Otherwise, it is binding
Right.
by default.
Yeah.
So, yeah, sure. We could definitely help with that. We should talk after the class and we can talk about that.
Kind of a long time though, no?
It's what,
Whatever you
See those often
negotiate.
though? Do you see
5 years?
Yeah.
Yeah, I did a 10-year.
10-year?
Yeah. A lot of the times, the reason you might want to do that, for example, I had a client who did a lease with option to buy primarily because they were going to be covering all the costs, including the taxes. The tax base was very, very low on top of which there was I think there was no mortgage. So if they were to buy it, they would have to pay a very high mortgage because of the interest rates. They would have to pay a very high tax. And this person was willing to essentially master lease the building to this new quote unquote tenant who was then going to be leasing it to the tenants, the actual tenants who were technically subtenants, and did this all on an option to buy where all the rent payments were structured so that they were paying towards the purchase price and then there was a lump sum due at the end. This worked for everybody because there was no increase in the tax basis. You can structure it this way where it doesn't get... Yeah, exactly.
Yes, with a balloon.
That's exactly what it is. It's exactly what it was. And there was a percentage that was incorporated into the monthly lease payments, which were really which were really purchase payments, right? But if it wasn't an installment sale because we weren't taking title, right? It was just a lease with an option to buy. But for all intents and purposes, it was an installment sale. So, but we never had to pay transfer tax, right? So yeah, there's a lot of clever ways to do it. Okay. Let's see. Any other questions from the board or from the room?
What about purchasing property through an auction, public auction?
What about it?
If there's tenants in there, and what the situation is. Like, let's say you have no idea what the tenant situation is, but you're purchasing property from a public auction.
I mean, very dangerous. We handle issues like that all the time. If you're talking about a foreclosure,
Yeah.
you're talking about a foreclosure? If you're talking about a foreclosure in, for example, city of LA, you can't evict them just because there was a foreclosure.
Right.
Right? So it doesn't work the way it does in normal real estate law. There's a special ordinance that says you buy a foreclosed house with tenants in it. It doesn't matter if those tenancy started before or after the deed of trust that was foreclosed, you're stuck with those tenants. Now, if it happens to be family members who weren't tenants, who didn't pay rent, if it happens to be the actual old owner or, random skeezy squatters, no, we can kick all those people out. But if it's actual rent-paying tenants, you're stuck with them.
If they're paying.
Not if they are paying, if they ever were or are supposed to be paying.
If they had a name on a lease associated with the property.
Correct.
And the best case is a cash or keys agreement in that case.
That is the best case, but a lot of the times the risk that you're taking is they'll say, no, we want to stay here. And you'll say, show me your lease. And they'll show you some fake lease that says they pay $500 a month. Prove that the lease is fake. You don't know. The owner's gone. He got foreclosed on. He ain't helping you. He's not happy. Right?
Man, this has been amazing. Thank
All
you
right.
so much.
Thank you very much. Thank you very much for having us, having me. And
I'd like to have you every Tuesday, please.
I don't know about every Tuesday. I do like driving out to Beverly Hills.
Once a month.
Where's your office?
My office is in North Hollywood.
That's not far.
Yeah.
You can make this your flexible office.
Okay.
You guys agree? You can come here anytime. I'm serious.
Well, thank you. Thank you very much. Appreciate it.
Here, and you can even put it on your letterhead. No problem. We want-
Fantastic.
Thank you.
Well, fantastic. Thank you guys so much. I'll hang out if you have any specific questions for a little bit, but appreciate you having me.
Any cool wants and needs today?